All right, well, good morning to everyone. I'm Attorney Joe Pippen, Ask an Attorney All About Florida Law is the name of my radio show. That's probably where you got my contact information from to join us today. So we're on our 5th Zoom seminar, and we're working on a YouTube channel of all of our Zoom seminars, and hopefully we'll be able to announce that pretty soon where you can come in and view some of the other ones we've done. We've done one on asset protection, estate planning. We've done them on Medicaid planning and so forth. Today's seminar is on living trust. And what I'm going to do is maybe talk for about a half an hour on trust, and then we'll go to the chat room and be able to answer your legal questions on the chat room, and then we'll probably take a few live calls so everyone can hear those as well and answer those. So so I'm going to talk for a half an hour, so we do that with no interruptions basically. And then I go to the chat room and answer those questions, and we probably the last 10 or 15 minutes we can do live questions from the audience today. So the first thing I wanted to do is talk about what is a trust. I get all the time this question, what is a trust? How's that different than a will? Are there restrictions? I'm going to talk about the common misconceptions of a trust. But what is a living trust? That's my first thing I'm going to talk about. A living trust is just a document. It's just a fancy will. The same questions I would ask you to create a living trust for you would be the same questions I would ask you to create a will for you. Both documents do the same thing. Both documents appoint someone to be in charge of your estate when you're no longer able to, either death or incapacity. A will only deals with death, but a trust deals with death or incapacity. Both documents have a plan of distribution. So you want your estate to be distributed in a certain way, and now you're doing a document that does that, and basically you choose a will or a trust. A trust is just a fancy will. So what is a trust? A fancy will is my explanation. It's a document you create. You're the grantor, you're the creator, you're the trustee, you appoint yourself the trustee. You own everything, you control everything, it's all for your benefit. So it's just a fancy will. It's a document some of the common misconceptions about trust. Am I restricted? Am I giving anything away? Are there any negative things about living trust? Do I lose my homestead exemption? Do I lose save the cap on the real estate homestead? Is there anything negative? Can I still do whatever I want to with my own assets? So the answer to the common misconceptions about a trust, I don't really think there are any negative things about a living trust. If you have one during the live question and answer session during the end of the program, then we can talk about it. And you can tell everyone what you think is a negative thought about a trust, and I'm going to tell everyone what I think, and to maybe counter your thought. Because I really don't think I've done, our firm has done over 50,000 estate planning documents. The highest percentage of those are in trust, and not just having a will, but having a will and a trust to avoid probate. So the common misconception, can I put my home into my living trust to avoid probate? Yes. Do you lose your homestead exemption? No, there's special language in the trust. Preserve your homestead protection. There's special language in the trust to not lose to save the cap. There's still portability. If you sell your home and buy another home, there's still portability, even if it's in a trust. So there are common misconceptions about real estate being in a trust are not true. You don't lose any of those benefits. So the common misconceptions about real estate are not true. And particularly if you have real estate in another state, you could have multiple probate in 2 states. I have a client that had like 7 properties in 7 states. We put all of those in a living trust. They're all going to avoid probate upon death because they're in a living trust, not a deceased person's name. Suppose you just have a timeshare in another state. Well, you could have probate in another state. Probate is the legal process of getting assets out of a deceased person's name. So if you die with a piece of real estate in another state, guess what? You're going to have an attorney represent you in that state to probate the property in that state. However, if you have a living trust and if you have your properties transferred to your living trust, you can have multiple properties in multiple states that all avoid probate. Why? Because when you die, they're not in a deceased person's name. And yes, even a timeshare would have to go through probate if you die with a timeshare in another state. Suppose you have a timeshare in Hawaii. Well, hey, it's real estate owned in Hawaii. Real estate is probated wherever it's located, unless it's in a trust or unless it's jointly owned. Unless you have another name on there, for example, it's going to go through probate. And you can avoid the probate process with a living trust. And you have multiple real estate pieces of property in multiple states. They can all be put in a trust to avoid probate. Many of my clients have moved to Florida. They still own a northern home or western home. They still own a mountain home. They still own some other piece of real estate. They might have a farm in the Midwest. They have some other real estate. If you have a living trust, all of that can be transferred to a living trust, be part of your estate that avoids probate because you took the proper actions to put that into a trust. Another common misconception about a trust is, does a trust have its own tax number? Do I have to follow? I had a question this morning already from one of my early clients. Do I have to? My wife and I have joint assets, was the question. And the husband in this particular case this morning had an individual trust because he had individual assets. And the question was whether or not they could still file a joint tax return. Well, yes, because a trust uses the tax number of the individual that created it. So in this particular case, the husband had a trust, and they had a joint trust. Well, both of those trusts had one tax number. Because the husband's name was first on the joint trust, the tax number is his social security number. And because the husband had his own separate trust, his social security number is used on that. So the husband and wife just both use as husband and wife, file a joint tax return and use one tax, that tax number for joint return, a husband and wife joint return. The trust didn't create any complications on keeping tax records. They could still file tax returns jointly. So I get this question all the time. When I create a trust, is it a different entity? Do I have to keep special tax records? Do I have to file a separate tax return for the trust? The answer is no. So a common misconception about trust is you have to keep special records to keep a separate tax return. That's not true. So the common misconceptions are what people think, or am I restricted? Am I giving assets away? Is there anything I can't do with my own assets when I have a living trust? Well, no, you're the grantor, you're the creator, you make yourself the trustee. The trust has what's called a grantor's life interest clause. What a grantor's self-life interest clause is that you can do anything you want to with your own assets. You're the owner of the trust. You created the trust. There's no restrictions on you whatsoever, whatever you do with your own assets in the trust. Now, there's a different duty when you die and the successor trustee takes over. Now, what that is the successor trustee that takes over your trust when you die has to pay your bills, can't ignore bills, can't ignore creditors, and they have to distribute your estate exactly like you've instructed in your document. Now, you're deceased, so they have to follow your instructions. It'd be a crime, it'd be a criminal act if they did anything self-serving or that would benefit themselves. So a trust has direct instructions, just like your will would. Trust has instructions on pay my bills, deal with creditors, distribute my estate as follows. The trust has all that language, just like your will does. And a trustee, a successor trustee, has the duty and obligation to do it exactly like you've instructed. And but you yourself are not restricted on what you can do with your own assets upon death. You can do anything you want to. The successor trustee has a duty to follow through and pay bills and distribute your assets according to your instructions. Now, some other misconceptions about trust are there assets you do not put into a trust? Is a trust for all assets? And do you have to put assets into a trust if you create one? Well, no, I call a trust a bucket. You can put whatever assets you want to into your trust to avoid probate. Your homestead, your checking, your savings, your money market, your stocks and bonds, all of those can go in a trust if you choose to put them in the trust. is if you have a particular reason not to put an asset in the trust, you can keep it outside the trust and own it jointly with someone else, or have a beneficiary on it for someone else, or have an in trust for someone else. Some people do that. They want to maybe not, you have 4 children and you want one of the children not to be involved in your trust for whatever reason, but you want to give them something, you could just make them a beneficiary on a retirement account or an insurance policy. It's whatever you want to put in your own trust, you can. You don't have to put all of your assets in the trust. As a matter of fact, there are some assets that don't go in a trust. You generally don't put an automobile in a trust. You generally don't put life insurance is not owned by a trust. Life insurance is not usually a beneficiary of a trust. Annuities, same way. You can have a named beneficiary on annuities, and they don't necessarily have to go into a trust. So generally the assets that don't go into the trust are retirement accounts, insurance, annuities, automobiles, RVs, boats, things like that. Now, can you put life insurance into a trust? And can you make the trust a beneficiary of your retirement account? Yes, you can. But usually there's a special purpose when you do that. For example, you have a child that is a spendthrift child, and you don't want the child to receive all of their inheritance at once. You want to make it last. You want to make it part of their retirement account. You want to have them have a monthly allowance from their trust because they've never had money on their own and wouldn't know what to do with a larger sum of money. The trust is a wonderful document where you can put instructions on distribution to last longer than a probate estate would last. The trust, in fact, a lot of wills create trust, and the trust is created only when you die. So it's called a testamentary trust. That's a trust that's created from a will when you die, but that all has to go through probate before it gets to the trust. The difference in a testamentary trust, one that's created from a will when you die, as opposed to a living trust, when you create it while you're living, is the living trust and assets you put in it do not go through probate. The testamentary trust is created when you die because your will says to create this trust with these instructions. So that means the asset is in a deceased person's name upon death. So that means the probate process. Now, if you have a special reason to stretch out a distribution to a child or other beneficiary, you can put those instructions in the trust. I'm a trustee of a trust, for example, where one of the children had an addiction problem, and there were 2 sons. Well, one son got his share outright because he was responsible person, married, children, responsible to parents, attentive to parents, and he got his share outright. The other son basically had an addiction problem. So what the person who died, he died recently. Soon after he created the trust, he knew he was under hospice care, and he wanted to do the right thing for both children. So he gave one child his money outright. He gave the other one his money over a period of time. And he decided he didn't want the one son that got everything outright to be the trustee for his brother because he thought that would damage the relationship between the 2 of them. So they named me as trustee. Now, the trust says that I'm to pay the rent for his other son directly to the landlord, find him a place. He was living under a bridge, actually, I think, when I took this up. But find him a place to live, pay the rent directly, pay his utilities directly, pay his medical bills directly, and give him X number of dollars every other week with food and other necessary things. Now, this trust will probably last 20 years because the amount of money comes out as a set monthly amount with the money's going to pay the landlord and so forth first, and the leftover money goes to him directly for food and other things. And he can request money for other medical reasons, and those monies go directly to the doctor. And basically, also the requirement in the trust is that he attend AA meetings, and he report to me as trustee. And if he's subject to random and mandatory testing, and if he fails the test and the addiction creeps back into his life, then the money is to be used for his rehab. And you can create a trust to take care of all these type of special needs. And you can appoint whoever you want to be the trustee in that case. It can be a family member, it can be a professional, it can be a bank with a trust department. So you can deal with addictions. If you have many families have addiction, people in the families that are beneficiaries have addiction problems. So the money can be controlled for their benefit. Suppose you have a spendthrift. Suppose you have someone that's never been able to accumulate any money and they don't know how to manage money, and they could use some help along those lines, and you don't want to give them a lump sum because you fear it would be used unwisely. So just give them a monthly amounts directly. They could all go to them, not like my first example. You could give them $2,000 a month, $3,000 a month, whatever the size of the estate, however long you want it to last. You just calculate that out and let you give a monthly amount. So if you give someone money that has an addiction and they just use the money for the addiction, you haven't done a very good estate plan. It's harmful to them. If you give someone a bunch of money and they don't know how to manage it and it gets wasted very quickly, then it's also harmful. You didn't do your best estate planning job. You didn't take care of family in a loving way by putting them in a situation where they wasted the money foolishly. Now, suppose you have a child in your family that has special needs, and they were to receive an inheritance, and they could lose all their government benefits, and they could blow through all the money very quickly and then have to go back on government benefits. So you can create a special needs trust to preserve all of the money and just be used for their extra and supplemental needs and not be subject to having them lose all the money before they can go back on government benefits. You could reserve it to improve their life. So I encourage everyone that's doing estate planning, whether you do a will or a trust, you talk to the attorney about any special circumstances within your family, because a lot of that can be dealt with in the overall estate plan to get a better result when you pass on, to put the money to a better use for the family member that's intended for. And a trust is an ideal way to do that, because if you just have a will, you can't do some of the things I just mentioned about special needs, addictions, or spendthrifts, because you don't want to have the court supervise all of that throughout a long probate process. If you have a living trust, the advantage of a living trust is that all of this can be done outside of the court without court supervision, and the trustee has a legal duty to follow your instructions exactly according to your instructions, exactly as has been spelled out between you and an attorney in drafting the document. Are there any tax negative things about a living trust? Well, here's how that works on taxes. When you create a trust, you use your tax number. The trust is a living revocable trust. You can amend, change, revoke the trust at any time, so the trust has your social security number. When you die, just like if you died with a will, you're going to have a new tax number for the estate through probate with a will. With a trust, the trust becomes a living trust. Now it's irrevocable upon your death, and it gets a new tax number. Now, the reason, most of the time on the reason we spin off the income in a trust, because income is taxed higher inside an irrevocable trust after your death. So if you do a stretch distribution, we spin off all the income and give the principal over a number of years, so their trust won't be subject to a higher tax rate. And on a trust where you have 3 children and everything's distributed outright to the 3 of them, we do that as quickly as we can, maybe even making a partial distribution, so there are no extra taxes involved in the overall estate plan. So I don't think there are any tax negative things about living trust. So a lot of people think there's some tax implication. You have to keep special records, it's higher taxes and so forth. All of that can be planned, so none of those things would be true. So let's talk about living trust on when there's a married couple in a second marriage or third marriage. It's not their first marriage, it's a later marriage. They enter into the marriage with separate assets, and they want to keep them separate. So in this case, now if you have a long-term marriage that has a couple, husband and wife own everything jointly, generally you would create a joint trust. Husband and wife can have a joint trust. If you enter into a marriage where it's a second marriage where you have separate assets, then husband and wife would generally create separate trusts to maintain separate assets. if you enter into a trust agreement like that, you need to know that a spouse has rights. They have spousal rights in Florida. Now, you might be watching in a different state. I'm a Florida attorney, only licensed in Florida, and everything I say today is based on Florida law. And it might be similar if you're in another state, but today I'm talking only about Florida law, Florida trust. A lot of the laws are similar in different states, but all of my comments today are basically Florida law comments. So in Florida, a spouse has a spousal right to your estate. So even though you might have separate trust, your spouse has a right to invade that trust if you die and take 30%. In fact, they have a 30% right to take assets that are even not in the trust, even the accounts maybe you own jointly with a child, or accounts you have beneficiaries on, or retirement accounts where you have beneficiaries other than your spouse. There's a spousal right to take 30% of all of that, and they can elect to do so with a court action. So if you have separate trusts, entering into your second marriage and have children from first marriages, and you have separate trusts, you need to consider what might happen when you die if the spouse were to exercise their rights to take 30% of your estate. They also, on the second trust, if one of you have the home and own the home entering into the marriage, your spouse has a right to live there for life and or sell the house and take half the proceeds. So there's a spousal right in Florida dealing with that. If you're married and didn't know these rights existed, or maybe you were married and didn't think it'd be a problem, and now you think it might be a problem, you can also do a post-marital agreement to waive those rights and have probably more peace of mind. But in second marriages, or more than second marriages, we often create separate trusts for both parties so they can maintain their assets. Now, you might be sitting there watching as a couple today, this presentation, and you might be thinking, well, this would never happen. We both committed to one another that we want our children from each marriage to have our estate, and we would never do anything to jeopardize that or get greedy when one of them die and take any assets. We totally trust one another not to do that, and we made a verbal commitment to not contest each other's estate and to honor each other's trust. That's just the way it is, and that's the way it's going to be. Well, hey, I've been involved in estate planning for a long time, and I've heard that said many times. And I can tell you also that many times when one spouse dies, the other one sometimes will listen to their children, who might even be their power of attorney, to exercise some spousal rights to continue their style of living. I mean, there are all kinds of reasons they come up with to justify their actions, to maintain their style of living, to get what they're entitled to. And sometimes the surviving spouse might already be in a nursing home, or might have kind of given up the control of what to do with their assets, and then trusting upon their children as power of attorneys, healthcare surrogates, maybe even a successor trustee is taken over, and they feel a duty to exercise their parents' spousal right. So sometimes it's not your partner that makes those decisions. Sometimes it's your partner's power of attorney, healthcare surrogate, living will are encouraging them to exercise their rights. So if all of that concerns you a little bit, and you would like to have the peace of mind, well, absolutely nothing's going to happen, then you might want to do a post-marital agreement if you're already married and in that circumstance. You would still have a separate trust, but the separate trust could be contested to obtain a spousal right, so you need to know that. So also, are there different types of living trusts? Is another area I wanted to get into. Can you have more than one trust? Now, I created a trust the other day. A person already had a trust. In fact, they had a husband and wife trust, and they were going to receive an inheritance. And they wanted to preserve their inheritance for their family and their children. So they wanted to keep that separate. They didn't want to commingle it as a joint asset. And their spouse is perfectly fine with that inheritance being kept separate and being given to the child who received the inheritance to their children upon death. Now, so what we did is we created a separate trust for this person. We created a separate inheritance trust. So the money was received as an inheritance and put into a trust account. Let's say John Smith Inheritance Trust. We gave it a name. And that money is kept separate. If that money was ever commingled, then it became a marital asset. So we had to keep it totally separate, so we created a separate trust for that John Smith Inheritance Trust, and always going to keep the money separate. Now, if the person wanted to use any part of that, they could, but when they died, their children took over as trustees, and it was all distributed to themselves. So there's a way to keep an inheritance separate where it never becomes a marital asset, and that's a way to do that. Does a trust have a termination date? When you create a living trust, does it become void at some point? Can you create a trust that could last a long time? The answer to that is yes. You can create a trust. There's what's called a rule against perpetuities language in most all trusts. So most people, the advantage of a trust is that you can have everything distributed out of your estate very quickly and very privately, as opposed to a will going through probate is going to take up to a year and it's a public record. But a trust, if you want it to last a period of time, you can do that outside of the court too. And it can last your lifetime, the lifetime of any beneficiary you've named, plus 21 years. So for example, if you gave all of your money to grandchildren, there are 1, 2, and 3, it could last their whole lifetime. Your trust could. So the rule of perpetuities is what I call a fictitious ending date, because it's a long stretched out trust. The purpose of the rule of perpetuities just gives a fictitious ending date. It must have an ending date. So you do this far-fetched ending date, and almost every trust I do would have ended way before the rule of perpetuities date anyway. But your trust can last for a long time. Some people create trust that their children don't have good retirement accounts. Some people make their trust kids the beneficiary, and then basically becomes their retirement account. So as creative as you want to get with a trust, you can. I had a gentleman one time creating a trust. He had 2 sons. He had one real successful son, and he had another son that he wished was a little more successful. So he says, we talked about it a little bit, and then I came up with an idea. I said, well, why don't you give your distribution? He didn't want to give it all to the one that was successful outright, and not do the same for his other son, but he didn't want his other son to get a large sum of money all at once that he might not know what to do with it or be wise with it. So what we came up with in this was to do a matching. The father who died left provisions that the trustee, which was not either one of the sons in this case, the trustee would match. He would do 50-50 distribution, but the money would only come out by matching what the son earned that year. So the son that had a great job and making a lot of money, he got his salary matched. So let's just say for conversation purposes, and this was a fairly large estate. So let's say son A, who had the good job, well-paying job and everything, made $200,000 a year. The distribution to him would match that. Now the other son at the time worked for a fast food chain. And let's say he made $15,000 a year. Well, the trustee's job was to match those salaries. And the goal of the father was the one in the fast food would want to have maybe a little more ambition to making a little bit more money so he could get it matched at a higher rate. So the point of the story, though, is that you can do whatever you want to do in being creative in the distribution of your estate and a trust or a will. The difference between the two is one goes through probate, the other doesn't. And even if you can create a will that creates a trust, it does the same thing, but why pay for the probate? The big advantages of a trust are no probate. It's quick, easy, fast, efficient. It's private. There's no court supervision of the trustee. So you need to be careful on who you pick as a trustee, which probably should be our next topic. Who should be the trustee of a trust that you create? Now you are, to start with, You're the grantor, you're the trustee. But in the document, you name a successor to yourself upon death or incapacity. Upon your incapacity, the successor trustee's job is to use everything in the trust for your benefit and the lifestyle you're accustomed. Upon death, your trustee has to follow those instructions. So who should that be? Now, I've had numerous clients come in and we sit down and talk, and they say they immediately think of, well, let's just name the oldest child as the successor trustee. Is that a good choice? The oldest child? Well, I don't know your children. My thought is the oldest child wouldn't be the first automatic choice. The first automatic choice should be the most responsible, trustworthy, financially astute child. The one, probably the busiest one, is going to get the most done and be the most efficient at it. The lackadaisical one, who really doesn't have any financial experience, no ambition to improve themselves and continually working hard to do all of those things, would probably not be your best trustee. So you need somebody financially astute, responsible, energetic, that's going to get the job done, that's going to be responsible to the other beneficiaries with reporting, accounts, tax returns. So they're going to be on top of it at all times. That would be your trustee. You also name a successor trustee, and that would be the second choice. Now, suppose like some families that I talk to, they don't have anyone they feel really comfortable with that could be a trustee and actually has the financial astuteness, the wisdom, the energy with dealing with their own estate. They don't have anyone in the family that they're going to stretch out the distribution to one of the children for various reasons. They just don't have a family member they feel competent to. Who should the trustee be? Well, you can choose a corporate trustee, one that has, banks have trust departments, brokerage houses have trust departments. There are a few independent corporate trustees. You could choose one of those. You can interview those and see what you think and get their fee schedules and all of that. So that's one choice. Another choice is to have an attorney or CPA be your trustee. Maybe you have a long-term or you really trust the attorney and you've met with them several times and they know a little bit about your family and they drafted the document to take care of special needs and distributions over a long time, and you have a comfort level with them that they would do a good job, and maybe they're experienced in having done many of those for other people, and you choose a professional, you choose an attorney or CPA or other professional and trust is financially astute, responsible, and can get the job done. Those would be the most common choices. Some people, let's say you have an outright distribution 50-50 to two children. They could be co-trustees. Or you can have one first and one second backup. Being a trustee is a job. And the job is to collect assets, pay bills, do taxes, make the distribution according to the instructions you've laid out. It's a job. So you don't have to treat children equally on giving them a job, and you can. But actually, sometimes two people that live, one lives in Florida, one lives in California, they both have to sign everything. If you make them it's going to be more efficient to pick one or the other to do the job as a trustee. So who should be the trustee? That's a good discussion point between you and your attorney creating the document to make the best choice. And whoever you choose now as a trustee can also be changed at a future date. Suppose you have a trustee, you name a successor trustee and they die before you do, or become very, very sick while you're living. Well, your trustee has a backup. When you do the document, you should have a backup. So the backup would need proof that the first one died with a death certificate. If the first one can't do it because they're ill, they can resign. There's a paper prepared to resign. You can get two doctors that have signed a statement that the person's not able to be trustee. That's usually enough to get the next one bumped up. So there are lots of different ways that you have named trustees and how they can all serve as a trustee. So the bottom line is I really don't think there are any negative things to a trust. A trust is just a fancy will You create the trust, you're the grantor, you're the trustee, you have a list of instructions on how the money is going to be distributed that must be followed. The successor trustee can't make up their own rules to be innovative on what they want to do with the estate. They've got strict instructions to follow. They can't do anything to benefit themselves. The benefit at the end of the day is there's no probate, there's no guardianship, it's quick, easy, fast, efficient, and it's private. All right, I'm going to go to the chat room here and see if you have any questions for me. I see some here. We can we'll go to the chat room and answer a few of those, and then we'll save a few minutes to end to take some live questions.
I don't know how to do it.
All right, so don't keep yourself muted until I call on you, so we don't have people overriding one another. So husband and I own a house together in another state, Massachusetts. Can I sell the house after he passes, or will it go to probate? Do I need to get the deed retitled in my name in order to avoid probate? Okay, so it says my husband and I own a house together. So I'm going to assume that that house says husband and wife, or it says tenants by the entirety, or it says jointly held with right of survivorship. So the question goes on, can I sell the house after he passes, or will it go to probate? Well, if it's jointly held, right of survivorship, tenants by the entirety, a death certificate takes his name off and you would have the right to sell it. It's already, do I need to get the deed retitled? It's already in your name, so following a death certificate just makes it yours and takes his name off of the deed. All right, so the next question is, can assets in a trust be potentially compromised, say, for instance, if you get sued or you owe money and the bill collector comes after you? All right, that's a two-part question. So a trust and you are the same entity, and you can do anything you want to with your assets, so you are in total control of those, so a creditor can get to those unless it's otherwise exempt. An otherwise exempt example would be your homestead or an insurance product. Insurance annuities, homesteads are protected from Florida law from creditors. But if your trust has cash, CDs, money market, brokerage accounts, that could be reached by a creditor. You and the trust are the same entity, so you'd be responsible for that. The trust is an asset protection document. If you ask me, can you create a trust that would be asset protected? You can, but that would be an irrevocable trust. And then you would have lost control yourself of what you can do with the assets in the trust. So most people just do a living trust. And if you're worried about lawsuits from a car accident, you probably get an umbrella policy. You have plenty of insurance to cover a car accident, and if it goes beyond your insurance policy. If you are in a profession, like a doctor, for example, and you're worried about lawsuits, then that's a whole different strategy to use. But a husband and wife owning things jointly, if the doctor gets sued, the husband and wife have protection in owning it as a couple. And if they sue the doctor, that's either one of them, they can't get to jointly held assets between husband and wife. And there's some other strategies to use in people in high-risk professions from being sued, like doctors, for example. The second part of the question is, what's the difference between a living trust and a qualified income trust? And how is a qualified income trust different from any other kind of trust? All right, so a living trust is a journal document used for a person putting their assets into to avoid probate, avoid guardianship, make it quick, easy, fast, efficient. It's just a fancy will. A qualified income trust is, for example, you would be trying to get on Medicaid, but you're disqualified because your income exceeds the amount of money you can have to qualify for Medicaid. So you create a qualified income trust to capture that extra income, so then you qualify for Medicaid even though you're receiving more that would disqualify you. You create a trust so you can be qualified, and the trust captures the extra income, so it's not countable. So a qualified income trust is just used basically for people they're in a nursing home trying to qualify for Medicaid benefits. All right, so let's see, I get a question here. Hey everyone, if you're eating, drinking, or doing other personal things you don't want Joe to see, you can stop your video. It's a funny looking icon, it's a funny looking camera icon to the right. So if you don't want to share your breakfast, a little question mark and a little smiley face probably. My husband and I had you create our trust several years ago. You prepared a quitclaim deed for our house in Florida. I remember you said it would follow upon our deaths. Is it correct, or should we file a quitclaim deed now? Most of my clients say do a quitclaim deed of their property to the trust, and that deed is generally recorded upon death. It doesn't need to be recorded now because you and the trust are the same entity, and there's no need to record it now. It's recorded by your successor trustee when they need to take action to be able to sell or transfer the house. So the quitclaim deed puts the property in the trust. Recording it only makes it a public record. It's signed by you, witnessed and notarized, and be recorded at any time. A lot of people choose to just have it recorded upon death, is the answer. Okay. Is there a set fee for a trustee to get paid? The general fee, the reasonable fee, the documents that I do down on the bottom of the first part of on the first page said trustees entitled to a reasonable fee. So what is a reasonable fee? A reasonable fee is 1%. If you go interview a bank or trust department, a brokerage firm that has a trust department, they all have a fee schedule. The fee varies from different sizes of accounts and so forth, but generally I would say on the average, the fee is around 1%. And that would be deemed to be a reasonable fee. And a trustee is entitled to a reasonable fee for the work they do. Now, having said that, do all trustees take a fee? The answer is no. A lot of family members, a lot of children, for example, as trustees do not take a fee. Why? Because the fee is income that has to be reported on taxes. And a distribution from a trust is not income, and it doesn't have to be, you don't pay income tax on distributions unless they're like a retirement account where the income's never been taxed, or an annuity where the income's never been taxed. It'd be an income tax when it comes out, but not an estate tax. And the estate tax is $11.5 million now. You all can leave up to $11.5 million in no estate tax. So estate taxes are not a big issue for 99% of America today because they're under $11.5 million in their estate. And if you're married, it's 11.5 each. So the next question is a state registered? Is there a state registered with the state? And if so, what department is there a certificate issued by the state for a particular trust? The trust document is not registered. It doesn't have to be filed anywhere. It's a private document. That's one of the big advantages of a trust. A will upon death has to be recorded at the local county where the person died. A trust does not have to be recorded. It does not have to be registered. Privacy is a big thing with a trust. So there's no certificate that you get from the state when you have a trust. It's all private. That's one of the biggest advantages, privacy. So the big advantages of a trust are no probate. You avoid guardianship because you got somebody managing your money. If you become incapacitated, that would be the successor trustee. Trust administration is quick, easy, fast, efficient, and it's a private document. Those are the four major benefits of a trust. So there's no public record, no trust. All right, can you get government benefits such as SSIs? Is it better to have qualified income trust of special needs trust? A lot of my clients with special needs children, we implement what's called a special needs supplemental trust provision inside the trust just to guarantee that they can keep the money in the trust at some point now or even in the future when you pass on, that government benefits would never be interfered with or interrupted or lost. So almost everyone that's getting some type of special needs benefit from the government that we find out about during the conversation, we add that language to the trust. My husband and I are Florida residents. I own property in my name only in another state. Is he entitled to spousal rights of 30% to the property? That's a good question. I would say yes, because you both are Florida residents, and the spouse is entitled to 30% of the assets. you know, a lot of bank accounts and financial accounts and other IRAs and all things are located all over the country. There's no requirement they have to be Florida. So I think this 30% spousal right pertain to assets in another state as well. That is one of the questions I get that I probably have to verify myself by looking it up a little bit later, which I'll do. But my first initial thought is 30% of everything, including property, no matter where it's located. Okay. Does the size of the estate matter? Well, to whether or not, I'm assuming to whether or not you create a trust or not. And the answer is no, the size doesn't really matter. The example I like to give is a person has $80,000 in cash in a home. Would they do a trust? Well, the answer is that a minimal, we have a minimal fee on probate. So almost regardless of the size of the estate, the minimal fee we charge is $2,500. And there's $500–600 in court cost. So let's just round it off and say there's going to be a minimum of a $3,000 fee with cost on almost any size estate, even if it's a fairly small amount. And even if it's a simplified probate through a summary administration, that's our minimum fee to deal with the probate matter. So if you could do a trust for, if you're a single person, $795, and if you're a married couple, $895, and you can avoid probate in the year of activity through the probate court, and being a public record, the trust is not just private, you have a choice. Do a living trust to avoid all that, or do you just do a will and go through probate? Now we charge like $150 for a will. So if you're a married couple, you pay $150 each for a will. You do a durable power of attorney, healthcare surrogate, those are $150 each, and 2 living wills are $75 each. So you're talking about $750 for those 6 documents. If you do a trust, it's $895, and all of those documents are included, plus your house. Putting that into the trust to avoid probate. So the fees are very, very reasonable to do it, at least in our firm, I think, to do a trust package. And you're spending just a little tiny bit more to do a trust as opposed to having just wills that will go through probate. And we have a fee schedule on our website, by the way, which is www.attypip.com. All right, so let me see if we have any more questions here from the chat room. Does it make purpose? Let me see. I have one of my checking accounts just using, does it make sense to do a trust with the sole purpose of placing your home in the trust? I think so, because the minimum fee that we would do petition to determine homestead and everything is still like $2,500. Should I change initials to my full name? A lot of people, I'm not sure I quite understand that question, but if you can use your middle initials. You don't have to use your full name when you're creating a trust. Let me see, I just had a note handed to me. Some may see pricing for a trust as a negative factor. Maybe discuss your pricing. Okay, well, I just did that. We charge we have flat fees on our website. If you're a single person doing a single person trust package, a trust, a will, a power of attorney, deeding your home to the trust, it's $795. If you're doing just a will, it's $150. If you're doing a will and a power of attorney, that's $300. Living will is $375. If you do a trust package, it's $795 for a single person, $895 for a married couple. The fee covers the trust, the will, the power of attorney, healthcare surrogate, deed of your home into the trust. All of that's included in the fee. Some of my appointments these days are by phone. You make the first appointment by phone. You can come to the office if you wish. If you want to just make a phone appointment, I can interview you and send you a draft of documents. That's basically how we work. If you want to come to the office and do a face-to-face, we do that. I take notes, and we can we'll send you drafts of documents. Either way, you get drafts sent to you to be able to look over a little bit. Unless you're on a plane the next day and have to do it the day you come to the office, you could probably do that as well. All right, let me see what it's, let's go to a few live questions. Let me do one more, then I'll go to live, and then I'll be my last chat room question, I think. I don't want to miss putting anything under my trust. Is there a checklist available that will list everything possible that could be put under a trust? What I do when I'm doing this for folks is that I give them an instructional sheet on how to get things into the trust. So this one-page instructional sheet tells you your trust name is, and it's like your name and the date of the trust on there, and it has a list of things that go into the trust: checking, savings, money market. So we give that with 2 clients as part of the signing process of the documents that day. And then we send them a letter every 3 or 4 years for review, or we discuss, registering assets to the trust a little bit, and then update any documents that need to be updated, which is usually just the power of attorney, living will, healthcare surrogate document. All right, so if you have a question, raise your hand and then unmute yourself here, and I'll call your name. Let's go to Mary Murray.
Actually, it's Tim. I'm doing it for my
Yeah,
wife.
I see it's a guy, so I saw Mary as your name there, though, on the sign in.
Joe, do you work with financial planners who have your finances to get everything in the trust?
Yeah, a person wants me to send a trust document to the financial planner and have any discussions with them, I'm glad to do so. So sure.
Thank you.
All right. All right, let's go to Bob. All right, Bob, unmute yourself.
There you go. Joe, I was trying to type the question. It didn't come out correctly. I have one of my checking accounts I have just with my first initial, my middle initial, and then my last name. Should I change that to my regular full name? In other words, I have it under C period, R period.
Well, do you have a trust?
Robert.
It depends on how you set up the trust. So if you don't have a trust and you set up a trust, you could do CR in your last name.
Okay. Well, I have a
take down the person's name as the way they would like to have their trust, their name on their account.
Okay, we have the trust with you. We got it about a month ago, and it's under my full name, Charles Robert.
Well, you either use your full name or come back in and amend the trust to have the name reflect the way you'd like for it to appear on the account.
Okay, we have like 3 or 4 checking accounts, and that's the only one that was with my employer. And so I just think it was a good idea to change it to my full name.
Yeah, well, if your trust is in your full name, yeah, I would agree. Just change that one to match everything else.
Great, thank you. Thank you, Joe.
Thank you. All right, anybody else have okay, let's go to, let's see, I put my glasses back on. It's Nargis. Okay, unmute yourself. All right, you're still muted. Down on your right-hand screen, you should have a little button where it's a little red line through your microphone. It says Nargis on the name. I'm not sure that's right. You got?
Okay, it is not.
There you go.
Sorry,
Yes.
I lost you for a second. I have a question about this reasonable fee.
Yes.
If it say 1% of the total assets per year, per month, when it goes into effect? How is it?
Well, it's per year, but your trust might last less than a year unless you put in special stretch provisions for it to last longer.
But when does it go into effect? When?
It goes into effect when you die or when the successor trustee takes over.
So at this point, whatever is a 1% of whatever the total assets are at the time.
Yeah, it doesn't apply now while you're your own trustee. Only when you die or become incapacitated.
Okay, thank you. And what does it mean, incapacitated?
You're unable to manage your own affairs. You either voluntarily resign and let the next trustee take over, or 2 doctors just state that you're not able to be trustee.
So it could be the incapacitated for other than health reasons?
Could be. It could be you're just tired of managing your own assets and like somebody else to pay your bills and take over and do things for you.
All right, thank you.
Okay. All right, who else has a question? Let's go to Jeff.
You said that you provided an instructional sheet for folks that you've done a trust for.
Yes.
Is that the sheet available on your website? Or is that only for your
Well,
client?
did I do your trust for you?
No.
Well, for me to do a good job on that, I would need to see your trust so I understand the name and date of it. So, I mean,
Okay.
everyone is individualized that I give to my clients.
Okay, thank you.
All right.
Protecting American business and workers. The
Oh, wait, who am I talking to now? Hold on.
Broadest U.S. trade enforcement action in 2 decades.
Oh, that's somebody's got their radio on or something. All right. Anybody else have a question?
Yes, I do, Joe.
All right.
Tom George.
Tom, go ahead.
My wife has her own checking account. Could you explain what a pour-over will and a trust is? Could we put that into the pour-over will?
Well, nothing gets put into a pour-over will deals. It says all my real and personal assets would be left to my trust. So the purpose of a pour-over will is kind of to catch the loose ends. And anything that's not put in a trust or it winds up in a deceased person's name, the will leaves it to their trust. So that joint account should maybe have, does your wife want you to have it if you die?
Well, she wants my daughter to have it if she dies.
Okay, so do y'all have a joint trust?
Yes, we do.
Well, she should probably just open up a bank account and make the daughter a paid on death beneficiary of that bank account, so the pour-over will wouldn't leave it to the joint trust.
Okay.
That work?
That sounds good. Thank you.
Okay, very good. Okay, one more question here because we're right at the end of the hour. Anybody have one more question for me? All right. Well, let me just say I really appreciate you joining today. I hope that helped you with some information that maybe you didn't know, give you a little peace of mind. If you would like our free estate planning poster sheet, we have a full-size poster sheet all about your options in estate planning. It's got diagrams of a trust and how it works. It's got on there little information about registering assets to a trust. It's got a comparison between wills and trusts. And it's got on the other side of the sheet has all of our attorneys and website and office locations. We have offices about all over Florida, actually. It has radio show information about my radio shows and all that. If you'd like that, you could email me and ask for the free poster sheet, and I'd be glad to mail that to you. I know a lot of people watching today are already clients and already have trust and probably already have the poster sheet, but if you're new and would like one, or even if you would just like one, that's fine. Just send me an email with your name and address, and I'd be glad to mail out the poster sheet. The estate planning poster sheet. It's a large size poster sheet with 5 articles about estate planning and all of our contact information. If you want to visit our website or the email address, my email address is Joe, J-O-E at ATTYPIP.com. Our website is just ATTYPIP.com. But if you want the poster sheet, just send me an email and I'll be glad to mail it out to you. I just need your name and address to Joe, J-O-E at ATTYPIP.com. If you want to listen to Ask an Attorney all about Florida law, we're on Saturday morning at 8 o'clock. The station comes out of Tampa, and there are several stations in the Tampa area. It's 570, 910, or 860 a.m. all on the dial. If you're down in Sarasota way, it's on 930. We broadcast live on Saturday mornings every other week on WeBeam TV. If you want to watch the radio show, you can watch it on WeBeam, WEBEAM TV.com. Also, we do it on Facebook.com. Also, you're welcome to join me on Facebook or LinkedIn, Joseph Pippen, Law Offices of Joseph Pippen. You should be able to find me there. Sunday mornings, we do a radio show on Fox News, iHeart, 970 a.m. From right now, we're doing it from 6 to 9 o'clock on Sunday morning. So you're welcome to join any of those. And thank you so much for being in attendance today, and I hope you have a great, safe, happy weekend. So long.
Bye-bye.
Bye-bye.
Thank you, Joe.
Thank you.
Thank you.
Thank you very much.